Well, good afternoon, everyone. I'm here to introduce a longtime friend, Diane Smason. I'll give you a little bit of Diane's background. She is a magna cum laude graduate of the University of Pennsylvania and a graduate of the University of Michigan School of Law. After law school graduation, she clerked for the Honorable Bernard Friedman on the U.S. District Court for the Eastern District of Michigan. And then she returned to her hometown, which is Chicago, and was an associate at Sun and Shine, practicing labor and employment law, as well as general commercial litigation. In 1998, she started as an EEOC trial attorney, and in 2004 was promoted to supervisory trial attorney. While in the legal unit, she litigated a wide variety of matters, including class and systematic cases under Title VII, the ADA, and the ADEA. In 20, let me get my dates here. In 2020, she served as the deputy director of the EEOC Chicago district and became acting district director in 2023. And this year she became an attorney advisor to the EEOC General Counsel, Carla Gilbride. Diane regularly speaks about EEOC and all areas of federal employment discrimination law, and she is actively involved in the ABA section of labor and employment law, is a current section council member. She's also a board member of the Federal Bar Association, the Chicago chapter, and was voted into the College of Labor and Employment Lawyers as a fellow. And Diane is here today to give us the basics about of EEOC law, and if there's time, and she can add a little bit of information about what's going on with discrimination and anti-Semitic discrimination that may or may not have come before the agency. So Diane.
Thank you, Joan, for that nice introduction. I'm so happy to be here. I'm thrilled Joan asked me. I see a couple of familiar names, so hi to those folks that I know. Can you, if you're able, kind of raise your hand just to tell me who of you might do employment discrimination law? I'm assuming not many, and that's fine, but I just kind of want to know so that. Okay, so I've seen about, a few hands. Good. So a few of you do know. So some, for those of you who do practice employment law, some of what I tell you is going to be something you already know, but I hope to provide some information for everybody that's new to you. Let me first start with just the basics for those especially who aren't familiar with the agency. The EEOC, Equal Employment Opportunity Commission, is a federal agency, and we're a small agency. We have offices in 53 locations, 16 district offices, and then local and area offices in other locations as well. Not every state, but close to every state. So the Chicago district office, where I've spent most of my career, covers 6 states, and it covers obviously Illinois, it covers Wisconsin, and we have an office in Milwaukee. It covers Minnesota, and we have an office in Minneapolis. It also covers Iowa, North and South Dakota, and we don't actually have offices in those 3 states, but charges from there are taken by any of the other 3 offices, depending on location. The EEOC enforces essentially 6 federal statutes or 6 federal laws. It all involves discrimination in employment. So we focus solely on the employment context. And the 6 laws, briefly, one is the one that you've probably heard the most about is called Title VII. And that prohibits discrimination, again, in employment based on several protected characteristics: race, color, national origin, sex, which includes sex harassment and pregnancy, religion, and retaliation. The other statutes, the Americans with Disabilities Act prohibits discrimination based on disability. ADEA is the Age Discrimination in Employment Act that prohibits discrimination based on age. The EPA, Equal Pay Act, prohibits discrimination based on discrimination in pay based on sex. GINA, Genetic Information Non-Discrimination Act, prohibits discrimination based on genetic information. And most recently passed new law is the Pregnancy Workers Fairness Act, the PWFA, that was passed by Congress and went into effect in June, at the end of June of 2023. And the EEOC issued regulations interpreting that law this past spring. So you may have heard some buzz about that. These are, and I'll talk more about the PWFA, but it's really an unusual law in that we've never had it before, and it bridges the gap in several protections for pregnant people. So as I said, we have 16 districts. In each district office, there's enforcement staff and there's legal staff. So I have spent most of my career on the legal side of the office, working within the Office of General Counsel. And as Joan said, I started my career as a trial attorney in the Chicago district and did that for over 20 years. What that means is we litigate employment discrimination cases based on charges that people come into file. We are not exclusively, but in large part limited to following up on allegations of discrimination that people bring to our attention through filing charges. And we now, in the past few years, have developed a whole online portal system for filing charges. And let me say generally that EOC has a very robust website, eeoc.gov. It's easy to find with tons of information about everything I'm going to be telling you about, some detailed statistics if you're interested, press releases about all the cases that we file and settle, not about charges though. So you should know that when somebody comes in to file a charge to start the process, that is entirely confidential on the part of the agency. We are prohibited by law from revealing any information about charges or even acknowledging their existence. It's once we file a lawsuit, if we file a lawsuit, that becomes public, and then we routinely issue press releases announcing the filing of lawsuits as well as resolutions of lawsuits. Every now and then you will hear about a resolution of a charge in conciliation before it got to litigation. We have to get agreement by the other side, by the company, to make that public, because again, the whole process prior to litigation is considered confidential under the laws that we enforce. When someone files a charge, they likely will have, more likely than not, they'll have the opportunity to go to mediation right off the bat. And we have a very robust mediation program all throughout the country with highly skilled mediators. Unfortunately, they're so popular, and really we get such great feedback on that program that they're often booked out for months. Both parties have to agree, though. So the charging party, as we call the person who filed the charge, and the respondent, the entity responding to the charge, they both have to agree. It is non-binding. It's not an arbitration, but you meet with an experienced mediator for a half a day or a day to try to get the charge resolved early on, before anyone really puts any resources into it, including the EEOC. There are certain cases that may not have the opportunity to go to mediation, and those may be cases that target a priority area for the EEOC, which I'm going to talk about, or that allege systemic discrimination. But the vast majority of charges filed will have the opportunity to go to mediation if both parties agree to it. The other areas, just broadly, that the EEOC does, in addition to taking charges of discrimination, investigating them, and litigating and settling them, in addition to that whole process, we also do a lot of outreach. We have people dedicated in every district to doing outreach to both employees and employers to inform them of their rights. A lot of training opportunities, some of which are free. Through the summer, we tend to have a lot of paid training opportunities that are really good and really sophisticated on different interesting topics for both employers and employees. And we have interesting speakers as well. We also have a federal hearings program where if you're a federal employee, you can file a charge of discrimination, and it goes through an administrative process. So it's a different process than what I described earlier as filing a charge on our portal and possibly going to mediation and then possibly being investigated. That's for the private sector. If you're a federal employee, it's a different process, and it's an internal process. In addition, we coordinate with all the state and local organizations that do what we do throughout the country, as well as some tribal organizations. And for most state and local entities or organizations that accept these kinds of charges like ours, they are cross-filed with us and with the state and local agencies. So if you want to file a charge against your employer, you can file it with the EEOC, and it will be considered cross-filed with the Illinois Department of Human Rights. And that's true in almost every state, and vice versa. If you file with IDHR, as it's called, the Illinois Department of Human Rights, it can be considered cross-filed with the EOC, so you don't have to duplicate your efforts. I mentioned earlier that we have priority areas, and I want to tell you a little bit about that. We operate under something called the Strategic Enforcement Plan, and that is renewed every 4 or 5 years. In 2023, we renewed it for the next 5 years. And that is when the commission identifies the priority areas that we're going to really try to focus on, not to the exclusion of anything else, but these are considered the areas that we're really looking out for and that we are more likely than not to file a lawsuit on. So one is eliminating barriers in recruitment and hiring. So we want to try to minimize the obstacles that people have to get their foot in the door for a job. So that could be companies using screening tools, for example, to screen people out, like criminal records, credit records as examples. And we're seeing more and more of that through the use of artificial intelligence. Employers are using more AI programs to screen people out. And that may be okay generally, unless it screens out people based on one of the prohibited categories that I mentioned. Another priority area is vulnerable workers from underserved communities. So that would be like migrant, immigrant workers, people who have mental health disabilities or intellectual disabilities, people who identify as LGBTQ, older workers, and younger workers. We see a lot of charges, as you may expect, for example, sex harassment against young women who are starting new jobs in retail or in fast food industries, that they too are considered under this priority of a vulnerable worker. We also this is sort of a broad catch-all that can be lots of different things, and we want to address emerging developing areas of law. So, for example, qualification standards, where you may have to meet a certain test to be hired. Pregnancy, because of the PWFA that I mentioned, that new law, this is an area that we are looking at much more closely than before. Backlash to like discrimination based on people's reaction to national or world events. And that would include like anti-Semitism or Islamophobia. Equal pay is always a big concern as well. You hear a lot about it based on sex, and the Equal Pay Act specifically targets that. Title VII also targets that as well. But also there can be discrimination in pay based on race, color, national origin. We see that as well. And that would come under Title VII. Also, a big area that our antenna is always up is access to the justice system, which translate into all kinds of retaliation. We see retaliation a lot, and I'll tell you more about that when I talk about the statistics of our charges. But it is very common for employers to get a charge of discrimination based on anything, race, sex, you name it, religion. And that charge may not ultimately even have that much merit, or it may, but either way, the company is really mad that the person filed a charge or even raised a complaint within the internal process of the company. So maybe didn't even file a charge, but asserted a complaint and asked that something be investigated. Employers tend to not take well to that. And it's quite common to see them engage in all kinds of retaliatory actions. The obvious being just firing somebody. Most employers don't do that right off the bat. They know that that's against the law, but there are all sorts of other ways you can retaliate against somebody, like giving them a different assignment, a less desirable assignment, moving their location, assigning them to a different facility, changing their hours. I mean, there's just all sorts of ways that can happen. And we see that. We see all sorts of retaliation. Also, other obstacles that might prevent somebody from accessing the justice system, like inhibit them from filing a charge. And that could be in work agreements, like overly broad waivers where you're waiving away all your rights. Certain releases that release a company from all sorts of employment claims, even if those aren't at issue in the particular case that a company is resolving with an employee. Non-disclosure, non-disparagement agreements, we see a lot of that. Improper mandatory arbitration agreements, we see those kinds of things. And EEOC puts a lot of emphasis on making sure people have access to the system, meaning they are free to file charges if they so choose, and don't fear retribution for doing that. And then the last priority area is broad as well, because it kind of covers all the bases. It's systemic harassment. And we see, and really what that means is just very widespread harassment, either widespread in a particular company, in a particular industry. And particularly harassment charges. We see a lot of that in terms of sex harassment, race harassment, harassment based on national origin status. Harassment really continues to be a problem. And in fact, I'll tell you some statistics, but so you know, in fiscal year 23, 38% of all charges filed against the country alleged harassment of some form. And our charges can allege multiple statutes, multiple bases and issues, but harassment has been alleged in over a third of all charges. So it's just a persistent problem. To give you some idea of the volume that we handle, EEOC nationwide in fiscal year 23, and let me say our last fiscal year 24 just ended September 30th, but those statistics have not yet been made public. They go through a rigorous process before they're made public. My guess is probably at least after the new year, if not before, those statistics will be on our website. But so I'm mostly going to talk about fiscal year 23 statistics, which overall aren't terribly different from 24, as I understand it. There were 81,000 charges filed throughout the country in all the different districts and local and area offices, 81,000 charges. Of those, 6%, or about 4,600, were filed in Illinois, in the state of Illinois. Our overall charge numbers have been going down, actually, from 2017, but then they spiked. They had been going down after 2017, but then they spiked. Fiscal year 22 and 23, the numbers started going back up to the levels of like 2017. And to give you some idea, nationwide, 34%, so about a third of all charges alleged some kind of race discrimination. Just behind that is 31% for sex discrimination. The biggest one is disability discrimination, and that has really gone up in years. We see so much of that. And just from my own experience, we filed a lot of discrimination cases this past year and continue to do so. Disability discrimination cases. That's 36% of all charges alleged disability discrimination. Retaliation, as I mentioned, is such a big issue and problem in all its forms. More than half of all charges allege some kind of retaliation, usually in addition to something else, like some, race discrimination, and then retaliation for having complained about it. Almost 57% of all charges nationwide in fiscal year 23 alleged some form of retaliation. Age is less in terms of numbers, 17%. National origin is even less, about 8.6%. Color is a little less, 7%. And then you all may be interested in religion charges, and I'll tell you a little bit more about those as we go. 5%. So religion charges overall are not a lot, really, only 5% of our entire charge intake. However, there was a big jump in fiscal year 2022 for charges based on religion, primarily related to the COVID vaccine. We saw lots of charges by people claiming that their religious observances, their religious beliefs were being violated by mandatory vaccine requirements that employers had. We're obviously now seeing far fewer of them, but there was a large influx of that. Let me tell you a little bit about recent developments within the agency. Just a few things to keep in mind that are kind of new on the scene this year. We issued new harassment guidance. As I said, harassment is just such an ongoing, persistent, and pervasive issue. We had not had specific guidance on harassment come out for about 20 years. So that's been updated, and that can be found on our website. And I also provided a list of resources for all of you on some of these bigger issues, generally about the EEOC, that you can, links you can click on for any information if you want more than what we're talking about today. And if you want to see the harassment guidance that was just issued in April of this year, there it is. I also mentioned a big development, the Pregnant Workers Fairness Act, which has now only been in effect for a little over a year. And EEOC has made a really big push to start accepting those charges, investigating them, and litigating them. And so at the end of fiscal year 24, which just ended a month ago exactly, we filed 5 new lawsuits under the PWFA. There are some other private lawsuits that people have filed, but not many because it's a new law. So we filed 5 lawsuits, one of which we settled already soon after we filed it. And then we also issued press releases on 2 charges of pregnancy discrimination under the PWFA that we did not file because we settled them in the conciliation process, which is an opportunity for parties to settle cases before the legal unit considers them for litigation. So in terms of getting cases resolved, you usually have an opportunity early on through mediation that I talked about. And then if a case continues to be investigated, at the end of the investigation, if the EEOC finds reasonable cause to believe discrimination occurred, the parties will get a letter of determination stating that, and then they will have the opportunity to engage in a process that's called conciliation. And really, it's just a fancy word for trying to get the case settled and resolved. And you don't go to a mediator at that point, but the investigator who's been working on your case will serve sort of as a mediator, an informal mediator, going back and forth between the parties to try to see if it can be resolved. If the case cannot be resolved through conciliation, then it will most likely be referred to the legal unit. The legal unit and all the units, and all of the Office of General Counsel encompasses the 16 legal units throughout the country. We review all these charges that have been winnowed down. So the attorneys tend not to see the bulk of the charges. We're really looking at those that have gone through the administrative process by being investigated, meaning they weren't settled early on or even throughout the investigation, which is always an option as well. But those that end up with a reasonable cause determination and that don't conciliate, those charges go to all the different legal units throughout the country, and the attorneys review them and make recommendations for whether or not we may want to file a lawsuit based on them. And those lawsuits have to be, in large part, they have to be approved by the general counsel. The current general counsel is Carla Gilbride. She's been in the position for a year now. She was appointed by President Biden. She has a 5-year term. I work as an attorney advisor to her. So along with her, I see the litigation recommendations that come in from the different districts. Some of those, depending on the nature of them, have to get approved by the commissioners. By the way, I should have said this earlier. I'm sorry. The commission is comprised of 5 commissioners. They are appointed by the president in office at the time, and the administration in office usually has 3 appointments from its own political party and then 2 appointments from the other political party that's not at the time in office. And those appointments are for 5 years. And a lot of commissioners get re-upped after 5 years. So they may be serving for 8 or 10 years. And right now we have 4 active commissioners. One commissioner, Sonderling is his name. His term ended over the summer in July. So right now we're operating with 4 commissioners. 3 were democratically appointed and 1 is a Republican appointee. Another thing I just want to point out is how a lot of people hear of the EEOC is obviously through charges, but also something called EEO1 reports. All companies that have more than 100 employees are required to file EEO1 reports every year with the agency. And you have to identify the nature of your workforce based on sex and race, and how many people based on sex and race there are in the various categories of positions within your agency. And that is an ongoing obligation. We here and there have difficulty getting compliance, especially some smaller companies, even if they're over 100, may not really be aware of that obligation or don't feel like they have the resources to do it, but it is a requirement under the law. And just this year, in fiscal year 2024, the EEOC filed 18 lawsuits specifically alleging that companies had not filed their EEO1 reports. This was a little unusual. The EEOC doesn't on a regular basis file those kinds of lawsuits, but we had been seeing more and more non-compliance. And so there was some urgency to try to file some suits to show employers that, no, you really do have to file these. And in almost all these cases, the employers wound up filing their EEO1 reports pretty quickly and the case is resolved. So those are kind of a few new developments. Within the legal units and the Office of General Counsel, as I said, we review cases for litigation and then file them. And there are trial attorneys throughout the country who file these cases from the beginning. They draft the complaints and they litigate them in federal court all the way through resolution or trial. We also have an appellate program within the Office of General Counsel. And that's something I've learned more and more about since I've been an attorney advisor to the General Counsel. It is a phenomenal program in that not only do they support any appeals that we have that on our own cases that we've initiated, but we file a lot of amicus briefs all throughout the country, mostly in appellate courts, in the Supreme Court as well. And we have a whole cadre of appellate attorneys who are really smart, excellent writers, and they are constantly looking for cases, like scouring dockets throughout the country for cases where we think the courts have gotten the law wrong, the laws that we enforce. And we often are looking for cutting edge issues, areas where the law is unclear and the EEOC wants to take a position and make a statement. This is how EEOC believes the law should be interpreted. One example of that got some publicity is a case called Mobley versus Workday, where the EEOC weighed in on a motion to dismiss in that case, which was in on the West Coast. I think it was California. And we provided a brief that laid out kind of all the different ways that we thought Workday, which is an entity, and we're seeing more and more of these, that support employers in their hiring and in managing their employees. Different ways in which those companies can be considered employers under the federal anti-discrimination laws, even if they are not a direct employer of somebody who, for example, was not hired by a client of Workday's, for example. So we laid out in a really thorough brief, like different ways that we think employers can be found liable. That's an example of one way in which on a cutting edge issue, EEOC will step up and take a position. Let me tell you a bit. Oh, and you can find those briefs, all our amicus briefs. And there were dozens we filed last year. I don't know exactly how many, but dozens. All of them can be found on our website as well. Let me talk a little bit before we end about litigation statistics, because you're all lawyers and probably wonder, like, well, how many cases do you file and what are those on? So in the past 5 years, the number of merits cases, like direct lawsuits, were claiming, like not subpoena enforcement actions, which we also do, but cases based on the merits, have ranged in the past 5 years, each fiscal year, anywhere from we file 90 to maybe 150. In fiscal year 24 that just ended, we have made public that we filed 110 cases, so kind of right in the middle. The year before, it was about 143, it was a little more. Similarly, resolutions, we tend to resolve almost the same number of cases each fiscal year. So anywhere from 95 to 175. And the range of total recovery varies, but it's pretty high. So, for example, in the past 5 years, our recovery has ranged anywhere from $23 million to $106 million. And in fiscal year 23, we recovered almost $23 million. And that money that we recover goes exclusively to the charging parties and any other aggrieved individuals, because we often file cases based on class cases, not class actions. We don't have to comply with Rule 23 under the Federal Rules of Civil Procedure, but we are able to bring class cases on behalf of multiple people, and all the money we collect goes to them. Like, I don't get anything. The agency doesn't get anything. We just get our regular salaries based on the budget that we get from Congress every year. To give you an idea, in fiscal year 24, we did make public the kinds of cases that we just filed over the past fiscal year. So 13 of them were new cases alleging systemic discrimination, which involves, as we talked about, like a widespread kind of discrimination or a pattern or practice or policy of discrimination. Now, out of the 110, 48 of them were filed under the ADA. And I had mentioned that that's the disability statute, Americans with Disabilities Act. That means almost half of them were filed with a claim of disability discrimination. And I mentioned we're just seeing more and more and more of those. As I mentioned, retaliation claims are very common, and over 40 of the 110 lawsuits that we filed alleged some form of retaliation under the various statutes that we enforce. 7 of those cases were alleging age discrimination. 5 of them, as I mentioned, were under the brand new Pregnant Workers Fairness Act. 5 more alleged sex harassment on behalf of teenage workers under Title VII. And I'd previously mentioned that's a priority area. Also, LGBTQ status is a priority area. 4 of the cases we filed last fiscal year alleged sex discrimination based on sexual orientation, and 3 of them alleged sex discrimination based on gender identity. And currently, of all the pending litigation by the EEOC, 22% of our current docket involves claims of systemic discrimination. So we really try to target cases where we can make a difference. Our budget is not very big. We are chronically underfunded. And so we're trying to use the limited resources we have to make the biggest impact. And that's why we tend to focus on systemic cases or class cases where we can make the largest impact. However, we still do file a lot of individual cases as well. I'm going to spend a few minutes before I take questions talking about religious discrimination. Given the nature of the Decalogue Society, I assumed that you would all have some questions about that. So there's some things I can share with you and some things I can't because I don't even know them. And that is, you can find on our website how many charges were filed in the past 20 years based on religion. As I mentioned, last year it was 5%. But the EEOC has not and does not break down, at least not yet, the different religions that people claim they've been discriminated against. So, for example, based on being Jewish or anti-Semitism, we don't know. I mean, I don't know, and the public doesn't know how many of those claims might be based on being Jewish. But I can tell you that we do get charges on that basis, and we do file lawsuits on that basis. And a couple examples of those, we resolved one back in 2010 against a company that does human resources called Administaff. And there were two brothers who worked for the company and alleged that they were the targets of slurs based on their religion. They were Jewish. And one of them had a swastika put on his car. We settled that case for $115,000 for both of those brothers. More recently, in 2018, we resolved a case against XPO Logistics for almost $100,000 for failure to hire somebody who, during the interview process, said he was Jewish and would need time off for Rosh Hashanah. And the job offer was revoked when they found out he'd need time off. So that was for religious discrimination and failure to provide accommodations. And as I said, that settled for about $100,000. Let me say, when we do settle cases, we settle for more than just money. We also settle, and this is what makes us different from private plaintiffs. The EEOC is always trying to make a difference, a long-lasting difference in workplaces. So not only do we obtain monetary relief for individuals who've been discriminated against, but we try to seek long-lasting changes at these employers. So we settle through what's called a consent decree that's filed in court and is enforceable by the courts. We usually file, it's usually for a period of several years. And there are some basic non-monetary pieces to that we require. We always will require that if the company doesn't already have a policy prohibiting the kind of discrimination at issue, that they must have that, and or maybe they need to revise their policy. It may be an old policy that needs to be updated, and that then be distributed to all their employees so people know about it, and it's not just sort of sitting in a manual in the HR office and nobody has access to it. We also require training. It depends the kind of training and who gets trained, just depends on the kind of case it is. We have an injunction against in further engaging in the kind of discrimination that we've alleged has been done. And again, it's an injunction in a court decree, so it can be enforced by a court if we think that there's a violation. We usually also have record keeping and reporting requirements, like the companies have to keep records for a period of years of the kinds of discrimination that we alleged in the case, and then report that to the EEOC so we can review how they've handled it. Typically, like in a religion case, it would be tell us going forward for however many years we've agreed for the consent decree to last, all the requests for reasonable accommodations for religion that you've gotten, and how you as the employer have responded, how you've handled that. Sometimes we require hiring of a monitor. If it is a systemic case, widespread, broad-based discrimination, especially if the company doesn't really have the internal resources to handle that and monitor that going forward, we may require that the company hire a monitor. So it really varies, and we focus on getting targeted equitable relief, really based on what the claim was about and the kind of relief that would be most effective based on the nature of the claim. So let me also say more generally in terms of our lawsuits. I told you about a couple that were on behalf of Jewish people for discrimination based on being Jewish. Last year, in fiscal year 24, we filed 3 lawsuits that had religion claims, not necessarily based on being Jewish or anti-Semitism, but more broadly, various claims of religious discrimination. And the kinds we see most often are failure to accommodate, like I mentioned on the one that was settled in 2018, where somebody says they need time off for a religious observance. That is very common. And we see that across the board, not just for Jewish workers, of course, for workers of all religions who have varying kinds of observances and practices, and they want to take time off. Like they don't want to work Sunday because that's their day to go to church, for example, like the equivalent of our Shabbat on Saturday. We also see a lot of religion claims based on dress, like garb, religious garb. So we see a lot of claims where men say they need to based on their religion, and it could be Judaism, but it could also be lots of other religions. They have to wear beards, that they're prohibited from shaving. And there are a lot of workplaces that have rules saying you can't wear a beard. So we see a lot of claims like that. Or for women, for example, we see claims of, nope, you're not allowed in this workplace to wear a long skirt. Maybe it's a bar or restaurant and they want to portray a different image, but that can be against the law. And in fact, one of our suits was based on that in this past fiscal year. It was Buffalo Wild Wings' failure to hire a woman because her religion required her to wear long skirts. She was not Jewish, it was another religion. In fiscal year 24, we also resolved 9 lawsuits based on religion. Again, not necessarily based on Judaism, but one was just resolved this October, earlier this month. So it'll be in statistics for like our next fiscal year, 2025. It was interestingly on behalf of somebody who considers himself a Messianic Jew, and he wanted to take time off for the high holidays, and his company, Center One, would not let him. And he ultimately felt like he had no choice but to leave. So those are some examples of the kinds of religious claims we see. And even if they are not based on someone's status as being Jewish, any and all of them all help advance people's rights in the workplace to observe their own religious practices, so they can benefit Jews and non-Jews alike, and move the law in a direction to be more responsive to employees' needs based on whatever religion they observe. So that wraps up my formal presentation, so to speak, or the things that I wanted to tell you about. We have maybe about 10 minutes for questions, and I am going to try to pull up, if I can, the questions. But I apologize. Of all days, my internet went out, and this pretty much never happens. And so I'm on my phone, which is a little trickier.
I can read you the questions if you like.
So would you mind? That would be helpful, because I'm having a hard time on my small screen kind of finding the chat with questions. So that'd be great. Thank you.
The first question is, how does the Chevron SCT Supreme Court decision impact the EEOC?
Well, that's a question that we all have. And it's yet to be determined, because for those of you who are familiar with the Loper-Bright decision that came out just a few months ago, the Supreme Court overruled Chevron, which gives deference to agencies in interpretation of laws that may not be very clear. And so at first blush, you think, oh, wow, okay, that may be a real problem. However, we don't really know. EEOC doesn't really invoke Chevron deference often. There's also, less kind of a lower level of deference that still exists, Skidmore deference. So it's hard to know. And I think we will see in the next year or 2 or 5 how the Loper-Bright opinion really does affect our agency and other agencies. It's hard to know, but I don't get the sense within the agency that people were like, oh my God, that's it, we're done for. Not at all. It may not it made headlines, but it may not in the end really make a big difference on what we do, the EOC does on a regular basis, and how we litigate and how we join in on other cases to state our opinion. It may not make a big difference ultimately, but we'll see. The jury's still out on that. So thank you for the question.
Thank you. The next question is approximately how much time does each case take from beginning to end on average?
That's a good question, and a long, long, long time. Not always, but I mean, for those of you who are litigators in any area, litigation can take a long time, particularly our large cases. Our systemic cases can go on for years. In fact, my mom always used to ask me, like, what are you working on now? And then she'd ask me, months later, and I'd say, Mom, it's the same thing. And years later, it's the same cases. And she'd say, don't you have new cases? And yes, we do. But some of the larger cases can in fact last for years. On the other hand, it's not uncommon for us to file cases and within a few months or a year, before a lot of resources are put into discovery, the cases settle. And in fact, already a handful of cases we filed in fiscal year 24 have settled. So it really varies. I mean, individual cases are more likely to settle earlier. And individual cases generally will probably last a couple, 2 to 3 years, very much on average. Large systemic cases, if they are really litigated all the way through, that could be easily 5 or 10 years. I worked on some cases that lasted 5 to 10 years. So
I'm going to take these a little out of order because one of these sounds like a good follow-up to the one you just did.
sure.
How often, if ever, does EEOC lose a case, whether on motion or at trial? Do you always appeal?
Yeah, that's a good question. I have to say very rarely, actually. And I just saw something, although I don't think it's quite public and out there yet, that we're preparing like for our annual reports, but we get favorable results one way or another in somewhere from like 95 to 98% of our cases. So we tend to do a lot better than private plaintiffs for a lot of reasons, in part because we are really screening the kinds of claims we bring. So we tend to bring very strong claims. I think judges tend to listen a little more when the EOC brings a case. They think, oh, this must have some merit. This must be important because we do sue on such a very small number of charges. Like, for example, I told you we got 81,000 charges last year, but we filed 110 lawsuits. So, and those weren't all based on charges last year, but just to give you a sense as to the volume of lawsuits is so much smaller than our charges. And at trial, I don't quite know what our percentage of win and loss at trial is. I mean, very few of our cases go to trial. Like any kind of litigation, most of them ultimately settle. Within the course of a year, we probably have nationwide a couple of trials, and we tend to do very well on them. Now, we don't always appeal. It really, or even on summary judgment, it just really depends on the case and the nature of the opinion, and if we think the judge got it wrong or if we think the jury got it wrong. So it really varies.
We've got another one here. Have there been any claims based on DEI program discrimination against those who are not included in the DEI umbrella?
Yeah, that's a good question too. So we haven't filed any lawsuits that I'm aware of recently, and that would really, be in that category. But there are private lawsuits. And in fact, the EOC has weighed in on a couple through our amicus program that I told you about. One of them was actually in the Seventh Circuit, and I'm sorry, but I'm blanking on the name, but it was a gentleman, and I don't remember where he worked, although I think it was kind of a well-known company, where he complained, I believe he was a white man, and he complained that there was a requirement to take DEI training within his company, and he didn't want to take it. He thought that it would, violate his freedom of expression, his First Amendment rights. And now this is not an EEOC case. It was a private case. He pursued this on his own. And we filed an amicus brief on it saying, no, that kind of training is not a violation of someone's rights. And the court agreed with us. I mean, the facts there were that this person did not actually even take the training. It was sort of what he assumed the training would be. So I think the facts were really against him, but EEOC took that opportunity, as I said, we do in amicus briefs, to sort of lay out what we think the law is and why those kinds of training programs are not in violation of the law.
Thank you. And I just want to let some people know that I'm skipping over some questions to make sure everyone who hasn't asked one yet gets a chance to be answered. Has there ever been a case when someone has sued for retaliation resulting from a request for family leave related to a protracted domestic relations division case?
So that is not something that the EEOC covers. We do not enforce the Family Medical Leave Act. That's enforced by the Department of Labor. However, there is overlap with what FMLA requires and what the ADA may require for people who have disabilities and need time off from work. And now that overlaps with the Pregnant Workers Fairness Act, that also now is has an affirmative requirement that pregnant people, employers need to accommodate pregnant people oftentimes by way of giving them time off. So we have a lot of cases under the disability statute, and we're seeing them now under the Pregnant Workers Fairness Act statute, where people claim they asked for a certain amount of time off based on disabilities, and they didn't get it. The employers didn't grant it. And we bring claims on that. Whether it's based on domestic violence issues is not something we'd cover, because it would have to be somebody who has a disability, or somebody who is pregnant or has gone through childbirth and has a related medical condition. That's what the Pregnant Workers Fairness Act now covers. So we have lawsuits that are somewhat similar, but that's not an area we enforce.
Thank you. Now I'll get this one. And Gail, if I'm not getting it right, you can unmute yourself and clarify. It's lore among plaintiffs' attorneys that cases filed by an attorney with the EEOC will not be investigated. Just request a position statement and send a right to sue notice. So Gail's asking, is that true?
Yeah.
And how can we actually obtain an investigation when that is what we want or need prior to determining whether a private lawsuit is appropriate?
Yeah, that's a good question. And I've heard this lore before. And here's the thing, that's not true as a rule across the board. By no means is that true. There's no rule that if you have a private attorney, we won't do an investigation. However, as I said, EEOC has very limited resources, and we have to pick and choose the cases that we're going to spend time on. And if we think there is a good employment attorney, experienced, knowledgeable, capable, who knows what they're doing, we're going to be less inclined to overturn every stone there, because we think, well, they have somebody who will be able to adequately represent them. Whereas people who file and seem to have strong claims and don't have attorneys, we're a little more interested in sort of using our resources to assist them. However, what I would say is, if you file a charge on behalf of a client and you want an investigation, let the EEOC know that. Let the EEOC know that you would like it to be investigated. Now, I can't promise you that every time you'll get a full-scale, full-blown investigation, but you might get more than you would if you didn't make that request. We are here to serve the public. And if that's something that you and your client want, talk to the investigator about it and say, what can you do by way of investigation? And maybe you can help them narrow it. Like, I don't need you to interview 20 people, but if you interview these 2 most important people, that would be really helpful to us to get a better sense as to the strength of the case. It would help us make a decision going forward what our next step is. So something like that, or ask for certain requests for information, specific requests, like, can you ask about all complaints for this? And that's something we typically would ask for anyway. But if you get the feeling that the investigator is not going to put much effort and time into it, and that's not uncommon, because again, we get 81,000 charges each year. It's a lot. And we have to winnow them out and make some really tough decisions about where we're going to invest our resources. But if you're an attorney representing somebody and you want some more work done, ask the investigator, ask the supervisor. If you're not making progress with the investigator, ask to talk to their supervisor, and maybe make kind of a limited request, like, please ask for these particular documents, and please interview these couple people.
And just as a follow-up to that, I almost always would put that list in my rebuttal to the position statement, and I've never had an investigator actually take the documents that I've requested. So, and usually if I had seen them, we would actually, we would have been able to resolve. So it makes it very frustrating. Then I can't have to wait another 6 months to get them in discovery.
I understand that. And as a litigator, I totally get that. And that is frustrating. We have a hard balance though, right? And I'm not going to defend every single decision that an investigator made, because I can't, but we do have a tough balance. There are so many charges, but I would say maybe send an individual email to the investigator, pick up the phone and call them. I mean, they get a bajillion calls. So, but to make yourself stand out a little, they may just read your rebuttal to the position statement, and if they can kind of make a decision on next steps without additional information, they may very well do that. But if you make a specific request, we'd really appreciate if you could do this. They'll go to their supervisor and ask. You may be told, no, we can't and we won't, but you may be told, yes, we will, especially, as I say, if it's sort of a narrow request, like, can you just ask for these documents?
Okay, well, thank you very much, Diane, for a great presentation. Thank you to our class for asking very good questions. There are a couple that didn't get answered, and as we end the class, if Diane has time to stay on, I'll ask her to answer them. But I just want to thank you all now.
Sure, I'm happy to spend a few more minutes, and or anyone can email me. My email is Diane, DIANE, .Smason, S as in Sam, M as in Mary, ASON. It's like an S in front of Mason, Smason, at EEOC.gov. So you can always email me too, and I can try to get a response to you, or look into something if it's not something that I know off the top of my head.
Hey, thank you so much. And thank you also, Joan, for getting Diane to come and speak to us today.